So, thank you so much for joining us here this afternoon. The theme of our conference today is Beyond Balalo, Recentering Transitional Justice as a Sustainable Basis for Reconstituting the Ugandan State. We are about 10 minutes late at this point, so I will just quickly take you through what our program looks like, and then I will welcome Dr. Businje Kabumba. So we'll start with the welcome remarks by Dr. Businje Kabumba, and then we'll have introductory remarks by Dr. Pius Ojara, followed by opening remarks by Dr. Benson Tusasire, representing the Dean of the School of Law. Thereafter, we'll have the keynote address, the response to the keynote address, and then we'll open it up for plenary. Without wasting time, let me invite Dr. Businje Kabumba to come and officially welcome you all to this conference.
Thank you very much. Good afternoon, everyone. Thanks, Mary. How much time do I have? 5 minutes? Yes, 4 now, actually, yes. So I'll try to make it in 4. Today is a very important day. It's 8th October 2025, 30 years since the promulgation of the 1995 Constitution. So it's a very good day in which to reflect on those 3 decades of the Constitution, see whether it has worked. Because the idea behind the Constitution is to constitute. A Constitution tells the story of a society. It tells a national story. It charts a path, a present, and then plans for the future. But, and I'm sure there are so many discussions going on yesterday, today, I think even tomorrow, around whether the Constitution of 1995 has done that. Now, one of the assumptions the Constitution makes is that the people of Uganda are a united people. The preamble begins with the famous words, "We the people of Uganda." And that's it's the basic and foundational and initial assumption. If that assumption is correct, well and good. If that assumption, on the other hand, is wrong, then a lot of what follows is problematic. And part of the idea behind today's conference is to test that assumption in the wake of recent events, such as the controversy around Balalo, whether pastoralists from Western Uganda can purchase land or reside in Northern Uganda. So it appears like a discrete issue, a one separate incident. On the other, you have had the long-standing question and the long-standing case for federalism as an alternative mode of governance. And there are so many other questions around the Ugandan state. The Buganda question, the Northern question, the land question, the Muslim question, the Asian question. Uganda is a land full of questions. In fact, perhaps more questions than answers. But very few, if any, of those questions seem to be foregrounded, acknowledged in the Constitution. And maybe, therefore, the initial presumption, the initial assumption, the initial statement in the Constitution, maybe the problems begin there. The assumption of unity where there's none. And that's really what today's discussion is about. Trying to locate what appear to be disparate and different issues in one particular conversation, that maybe this is what we should be talking about. That maybe there is something that connects what appears to be a separate Balalo question to the federal question and other questions. And to have this discussion today, we could have no better persons than Senior Counsel Francis Gimara, who is with us today, and Honorable John Ken Luchambuzi, the man who is also with us today. And I would also like to acknowledge the support and the partnership of the Refugee Law Project of Mackay University, represented here today by the Director of the Refugee Law Project, Dr. Pius Ojara. Thank you so much. So, really mine is to welcome you to this discussion. I will not introduce our guests, the moderator will do that. Dr. Pius will also tell us a little bit more about from the context of the RLP, but we're also privileged to have in our midst Dr. Benson Tusasire, representing the Dean of Law. Thank you. And thank you also for joining us for this conversation. And I think I've exhausted the 4 or 5 minutes, and I'll leave it at that for now. Asanteni.
Thank you so much, Dr. Businje Kavumba, for that very brief welcome. I would like to use this opportunity to welcome Dr. Pius Ojara, the director of the Refugee Law Project, to come and give brief introductory remarks, no more than 5 minutes.
Good afternoon. I believe not many of you have met me before. I'm the director of Refugee Law Project, which is an outreach project of the School of Law, Makerere University here. Senior Counsel Francis Gimara, Honorable John Ken Luchamuzi, Dr. Benson Tusasirwe, representing the Dean, Dr. Businje. I'm very delighted to stand here on this second annual conference on human rights, peace, and social justice. It's the first time I'm speaking at the School of Law before an audience. As Refugee Law Project, we are like a sister institution of EURIPEC, and that's why we joined up on this annual event, and we have agreed we will be doing this annually for the next few years. And I'm very happy we're able to do that. Refugee Law Project, as I said, was established in 1999, initially under Makerere Act, and then later under the amended Makerere Act, which became the Tertiary Education Act, and were really established to focus and support displaced persons, asylum seekers, refugees, deportees, internally displaced, to ensure that every Ugandan is able to live a dignified life irrespective of legal status or vulnerabilities. And we are a bit big. I have a staff of 195, and we are present in a number of the settlements. We have sub-office in Kawempe and Tebe, and of course our main office in Mengo. And we do work around research, primary policy research. We do work around gender and sexuality, do work around mental health and psychosocial well-being and livelihoods. We do work around peace, conflict, and transitional justice, as well as on media for social change and access to justice. We started as a legal aid institution. With respect to this conference, actually, we had an idea. We wanted it named after Professor Joe, who declined. Professor Joe declined because I said, look, why should we not honor our own? I want us to start honoring our own. But Professor Joe indicated very firmly he did not want this conference named after him. I had made a commitment that for the next 5, 6, 8 years, we would be calling this after him to honor him as one of our own. But we also respect his position in that respect. He's at the foundation of both EURIPEC and Refugee Law Project. That's why we wanted that. Now, for this conference, I'll go quickly. Dr. Businje said there's a lot of assumption of unity. I want to say there's one thing about Uganda that has not changed, the national anthem. The national anthem of Uganda has not changed from independence to date. And I want to read to you stanzas 2 and 3. Stanzas 2, O Uganda, the land of freedom, our love and labor we give, and with neighbors all, at our country's call, in peace and friendship we live. That's stanza 2. Stanza 3 says, O Uganda, the land that feeds us, by sun and fertile soil grown, for our own dear land will always stand, the pearl of Africa's crown. The very topic of this conference, Beyond Balalo, recentering transitional justice as a sustainable basis for reconstituting the Ugandan state, actually speaks to these two stanzas. And as I say, despite a number of social, economic, political changes in Uganda, our national anthem has not changed. What does that mean? It means that we should actually use the national anthem as a basis, as one thing around which we should rethink patriotism, socio-economic transformation, Pan-Africanism, knowledge and democratic principles and practices. That is where we can certainly secure this, because it is one thing around which we can say the same thing. In other words, we can test the well-being of the Ugandan state using the standards and principles underlined in the national anthem. It's very interesting if you actually have a study, what are the principles underpinning that. So the topic of today, Beyond the Balalo, which is around the Balalo question, really reflects the expression of certain forces that are shaping the Ugandan society today. When you hear that, that's what is at play. They embody socio-economic, political, and historical dynamics that are touching on the hopes and fears, frustrations, and longing for a stronger and just tomorrow. That's really what is driving this urge. There is then certainly a yearning for some assurance. There's a longing for some assurance that needs to come from the Ugandan state. Perhaps as experienced or expressed in widening inequality, economic instability at household and community levels, or social polarization as expression of larger forces at work in the Ugandan society. And these forces are themselves creating uncertainty and insecurity and the pressure that people feel left out. So the topic of today reflects the question of the conditions of the Ugandan society in terms of what is possible. Because if people thought it was not possible, they would not be longing for that. In terms of what is possible, in terms of what needs to be addressed, because the risk is one of erosion of trust in people and institutions. And there is thus a need to build trust in people, in institutions, revitalize the energy of hope through building of legal, political, economic systems that serve all, sustain all, and which endures. That is the cry underneath all of that. Why? Because people need economic and social systems that provide security of well-being for all, through increased opportunities for all, through tackling and addressing of inequality, through strengthening social safety nets, and ensuring prosperity that is broadly shared. In other words, renewal is required, as per our national anthem, stanzas 2 and 3. So the question of Balalo really is about people requiring relief from perceived burden because they have become distrustful and anxious, and it is perhaps a symbol of social and economic conditions that are not favorable, and it is also about accountable participation and accountable constitutional order. In this sense, we have to appreciate that the forces of history ordinarily gather momentum in the lived experiences of ordinary citizens, momentum that beckons repair, that beckons rebuilding and transforming of certain aspects of the society. They ordinarily reflect contradictions in the Ugandan society itself, and it is important not to ignore the emerging discontent. It is important to listen to the cries and make these the basis for shaping new opportunities, new imagination for a new Ugandan, and a new expression of our constitutional order. As I said before, one thing that has not changed is our national anthem. That means Uganda has been a resilient society. Uganda has been a society of better choices, of renewal and foresight, amid history and layers of unresolved contradictions, corruption, polarization, and social dis-ease. The way forward, therefore, requires courage, change, improvement, and rebuilding of trust in people and institutions. So these are my remarks on this second conference, which I'm really looking forward to hearing the keynote address from Senior Counsel Francis Gimara and respondent Honorable Ken Luchamuzi, a seasoned political pedestrian in the Ugandan landscape. Thank you very much.
Thank you so much, Dr. Pius Ojara, for that very summarized yet also similarly detailed introduction of the topics that we'll be discussing today. I think it's clear from your address or from your remarks that although the issues that we are going to be interrogating this afternoon seem to be specific to, for instance, issues of the Balaa Law, the background or the history that leads to that is joint, it's united, it's the same. We have the context, the historical context is the same for the bulk of the constitutional challenges that we might be facing as a country today. So I'm looking forward to the discussion, to seeing how this then gets narrowed down or widened further in the keynote address. But before we get into that, I would want to welcome Dr. Benson Tusasire to come and give his opening remarks on behalf of the Dean of the School of Law. Let's put our hands together.
I was seeking clarification from my true boss. My learned friend, Senior Counsel Francis Gimara, my learned friend, Honorable Ken Luchamuzi, Dr. Jala, Dr. Kabumba, ladies and gentlemen, it's an honor to be here in these assumed garbs of the Dean of Law. This should have been done by Professor Naruwairo, the substantive Dean of Law, but he's not around, and so I have been inflicted on you. And so for the next 5 or so minutes, you have to put up with me like bad medicine. In that capacity, I'll do 3 roles. 2 on behalf of the Dean and 1 on my own behalf. So on behalf of the Dean of Law, I take this opportunity, dear keynote speaker and the Honorable, to welcome you to your alma mater. This place nurtured you. It contributed. It didn't make you what you are. It contributed to what you are. One time, Maria Mabirizi told me I made him what he is, and I told him in that case, I'm sorry. I hope he's not around. So this press didn't make you what you are, but it contributed to what you are. And giving back in this manner is very much in order. The young people you see here need nurturing, and it's not enough to give them academic content. They need to know that beyond the walls of this university, there is a life, and it must be lived in a certain way. And beyond that life, there is a nation called Uganda. If they don't get that straight, they become a problem to the country and to the world, and of course to themselves. So thank you for coming to help in that task, and karibuni to your alma mater. Thank you. I also want to thank the students who are here. That you are so few is testimony to what is wrong with this country. When we were here, I came to this university in 1991, before many of you were born. And on the day that the constitution you have talked about was promulgated, I had finished LDC and was already employed, because I finished LDC in July of that year, 1995. So you see, we have been here for quite a while, and we have seen water flow under the bridges. But when we were here, if something like this took place, we would be packed like sardines. We were hungry for experiences and knowledge, but that has since passed, for which we are sorry. Maybe we are to blame. But I welcome you, those who have managed to come. I know the rest will drip in as we go along. By the time we are done, it will be full. That's part of the indiscipline that makes us Ugandans. Totally indisciplined. Now, this arrangement of today rhymes very well with the mission of the university today, of Makerere University. The old university model created what we call the ivory tower. Scholars were not supposed to mix with the rest of the world. They were not supposed to be exposed to what they call the littleness of the world. They were to be tied in the laboratories and in the great libraries and propagate knowledge from the quietness of those places. But what that meant then is that they were detached from the world for which they were supposed to generate knowledge, and often the knowledge they generated was irrelevant to the needs of society. The Humboldtian model which we espouse changed that and worked for universities which address the needs of society. So the mission of Makerere University now is threefold. One, teaching, which we do very well. I have passed here when Professor Kavumba is propagating knowledge, and I know he does it with a sense of duty and industry. And so do I believe, and so do the rest. The second one is, of course, research, but research for a purpose. So research, dissemination, and innovation. Research and innovation, which we also do fairly well and increasingly better. Now, the third one is community outreach, which is now emphasized. Now, community outreach works both ways. We go out and interact with the world, but we also bring the world to interact with us, and that explains the two gentlemen you see in front of you. They are bringing to you the richness from out there to help you put some sense to the theories we teach you about the rule of law, separation of powers, the concept of human rights, and so on and so forth. What do they actually mean in real life? Now, those were on behalf of the dean, that what you are doing fits the mission of the university, and so the university and the School of Law supports it. But that's all. Now mine is just a brief comment, don't worry, about today's theme, Beyond the Balalo. And then, of course, the search for justice and so on and so forth. First of all, I find the theme relevant, the idea of Balalo. It looks small, but big things start small. If you mismanage the Balalo question, it can become a national crisis. It can bring down regimes. It can trigger national internecine violence. It can even trigger a genocide. So it's not a small question. But two, the way it was formulated beyond Balalo, you have to look for the real crisis beyond the idea of Balalo in northern Uganda. It is a manifestation of a bigger problem. So what actually is it? Some people think that the Balalo problem in northern Uganda is simply a land grab disguised as nomadic pastoralism. That's one way of looking at it. Others could say it is a crude effort at creating capitalism. You see, in Europe, capitalism was created by destroying the peasant class through what is called the enclosure movement. You take to the land, you chase out the peasants, you enclose it in fences, and you start modern agriculture, which supports industrialization and the growth of the middle class. Now, you have heard that the Balalo have been advised to either leave or fence the land if they bought. When you fence, you are starting on the enclosure movement. Those who have fenced out must find where to be. If they can't feed because now they don't have land, they die off. Those who survive become labor in industries. Those who can't fit in the industries migrate. 6 million Scottish, 5 million Irish left the UK to America. Others went to the industries, and the industries gave way to the modern towns, and urbanization swallowed the rest of the jobless ones. But millions of peasants perished in hunger. So could this be a way of creating what we have been told is a middle class that is necessary to trigger modernization in this country? If so, you had better pray if you have any God to pray to. But for me, I look at it as one manifestation of the northern question. The Balalo question is part of the facets of the northern question. And the northern question is part of many questions which Dr. Busingye mentioned, which are part of a bigger question. So you have the Buganda question, you have the Bunyoro question, you have the Asian question, you have the agrarian question, you have the land question. All those are part of a question called the national question. The national question is a question of what is to be the form of the post-colonial state in Uganda. How do you create a nation out of 50 or so sub-nations which were forced together into a marriage that they did not like, called Uganda? How do you do it without them turning on each other? That is the national question. And one of the manifestations is the Balalo question. So the Balalo question is, therefore, I think I'm going to stop here. I can go on? Thank you. The Balalo question, therefore, is just one of many questions that are forcing a struggle to identify who we are. And when we don't answer it well, we will not have Uganda, because we also will not have answered the other questions. It's a headache. And there are about 3 ways of treating a headache. The extremists treat a headache by cutting off the head. Since there will be no head, there will be no headache. But that also means that the organism dies. See? So that's not a solution. The other solution to headache is to use painkillers, Panadol and so on. That gives you temporary relief. But while the pain is gone, the cause of the headache remains. And by the time it comes back, when the painkiller wears off, it is normally worse. So if you treat the national question with painkillers, you not only delay the hour of reckoning, you worsen the consequences. One way of treating a national question with painkillers is tokenism and appeasement. Appeasement, in a short term, looks like solving the problem and there is peace. But below the surface, you are brewing a bigger problem. And in most cases, then it gets out of hand. So to me, appeasement should only work as a short-term measure as we work on the third solution to headache. You see, a headache can come from anywhere. You can have a headache. When you don't eat and you are hungry, you feel the hunger in the stomach, but you also feel it in a headache. But also when you eat too much and you have a constipation, you feel the pain in your anus, but you also feel it as a headache. So if you treat the headache, you are not addressing the problem in your stomach, and it can get worse. So the best treatment to headache is to find out what is causing the headache and address that. But in the meantime, in the short run, you can use painkillers to ease the pain as you solve the bigger problem. That is a better solution to the national question. So, are we looking for the real problem, or are we only addressing the headache? Workshops of this nature are important because they help us to try to find the solution. People think it's silly to talk, but if you think talking is silly, try shooting at each other as an alternative. Then you will know. In talking you can annoy each other, but from that annoyance can come a solution. So it is always better to do this kind of thing, because by examining what is wrong, by subjecting it to scrutiny, hopefully you find the problem and therefore the solution. Some people have addressed the national question in many ways. Britain had it. I have told you they were the Scottish, Irish, the Welsh, and so on. They fought each other, killed each other. Eventually they resolved the problem by agreeing that each of those nationalities must be represented in power and in economics. And now they have resolved the problem. After India got independence, it had a problem also of nationalities. The Sikh, the Gujarati, the Muslims, and the Hindu. For them, they solved it by partition and forced the Muslims to go to Pakistan and the others to remain in India and the other ones to go to Sri Lanka. Eventually, it didn't work, and they had to create another one called Bangladesh, which was formerly East Bengal. They kind of solved the problem. They point fingers at each other, they're always threatening each other, but somehow they survive. See? The Congo, DRC, refused to address the problem of being too big and too rich. And now they are one stage away from being a failed state. The West Africans, French, Francophone West Africa, so they would solve the problem of post-colonial order by remaining a colony and signed something called the Pact for the Continuation of Colonialism. Today, they are clueless. They are in the mire. Sudan failed to solve the problem of the national question because their problem was race, Arabs versus the blacks. Eventually, they kind of solved it through partition. Ethiopia also tried to solve it, first through violence, stopping people from protesting physically by shooting them. It didn't work. Eventually, they accepted a partial partition and created Eritrea. It has not worked. The Matabeleland, Mashonaland problem in Zimbabwe, they have tried to solve it again through suppression of voices. It has not worked. That shows you some of these solutions will not work. South Africa and Tanzania kind of tried, and maybe those are the examples we should look at. As apartheid was ending, the problem was, how are you going to stop the black people who had been oppressed for 400 years from killing off the white people? Mandela had to forgive, to pull from very deep and forgive those who had oppressed him. And he held the nation together. But you know, after he has left from apartheid, they went to a time of containment. Now we identify South Africa with two things. One, urban crime, and two, xenophobia. But the Mandela model had seemed to work, so we can look at it, involving everybody. Tanzania possibly presents the best picture. Tanzania is made the same way Uganda is. They brought so many nationalities together and forced them into a union. But for them, they have addressed it. If you ask a Tanzanian which tribe Nyerere comes from, or Mkapa, or Mwinyi, or Kikwete, or the lady, Suluhu, they don't know. Tanzanians never think in terms of tribe. And it was because Nyerere consciously worked on it. They know themselves as Tanzanians first. If you meet them anywhere, me and the senior council have been meeting them in East African Law Society, they are distinctly Tanzanian and they don't think tribe. Maybe that's the way to go. But can you do that when you are doing appeasement? That is the question. And maybe that's one of the things we will address today. So with those few words, on behalf of the Dean of Law, I have the honor to declare this symposium open.
Sorry. Thank you so much, Dr. Benson. I think you'll all agree with me that the scene has been set. There is not much I can add. Like, I would just dull it if I tried to. So without wasting time, I'm going to introduce and welcome our keynote speaker. So the keynote address will be delivered by a well-respected legal practitioner and scholar who has cross-cutting experience in several areas, including regional integration law, corporate governance, and several others in that line. Amongst other distinctions, he's also the former president of the Uganda Law Society. He's also the founder of ALP East Africa, a legal services hub which has presence in several countries, including Uganda, South Sudan, Tanzania, Nigeria, Kenya, to mention but a few. And they specialize in a lot of things. But also, our keynote speaker has been a critical voice and thought leader, spearheading the protection of communal land holding in northern Uganda. That is why he's here today. Let's put our hands together, rather, to welcome Mr. Francis Gimara, Senior Counsel, to deliver his keynote address.
Thank you so much, moderator. I acknowledge the introductory remarks of the representative of the Dean, Dr. Benson Tusasirwe. I enjoy listening to you. And at one point, he made my work very, very easy. I almost told Dr. Kavumba, I think you can make me a discussant now. Because he has saved a lot of what I was going to say. But let me also recognize Dr. Kavumba and the Huripek fraternity, Dr. Pius Ojara, and the RLP family. Let me also acknowledge the man, the discussant of the paper, distinguished legislator for very many years, Honorable Ken Lukiamuzi, and indeed, you guests, colleagues, students, and everyone here. It's a big honor to address you in this auditorium, which is very historic. I think about 98, we could have been the first people to have entered it or thereabout. And I recall I sat where that gentleman in white sat up there, and in front was now the newly appointed IGG, just sat in front of me, the one who was appointed yesterday. So I have very fond memories of this room, this lower auditorium. And I also recall in this auditorium we were treated to a number of very good lectures by very distinguished people. I remember Oloko Nyango discussing the ex parte Matovu case like nothing before. He had just published his book on judicial independence, and the floor was very, very inviting. I remember many other lecturers like Dr. Juko, and he used to stand here and explain the doctrine of res ipsa loquitur. He would say, res ipsa loquitur, who doesn't understand it? He said, when you see a woman pregnant, do you ask why? That's res ipsa loquitur. And I'm done with explaining that doctrine. I also remember Professor Bachivinga discussing equity. Is equity still taught here? I recall one particular incident where he put a very strict deadline to submit coursework by 4 p.m. And almost half of the class missed out. So when he came to start teaching, he closed his office and took those who had submitted and proceeded to teach. And that very class, he was teaching us on maxims of equity. And you know, equity is about tempering the unfairness of law, the doctrine. So after speaking about those maxims, one particular gentleman, I think he's now in police, Ian, said, now, sir, based on the maxims of equity, can't you consider us? We submit our coursework. He said, sit down, sit down, sit down, sit down. Then he kept quiet and responded by saying, equity follows the law. And he proceeded to teach us. So I am deeply, deeply honored to return to this place. I thank you, Dr. Kavumba Businje, for the invitation. And I come to discuss an issue that is very topical. I have how many minutes? 30? 25, okay. It's very good for me because I have a tribunal hearing this afternoon. I'll make use of that. The Balalo issue, is it a Balalo issue? These are the questions I want to start with. 2, what does the Constitution say about it? What do the courts of law say about the Balalo issue? And do we have a state today capable of handling this matter in a way that fosters unity and harmony? But before I answer those questions, I would like to start by saying the debate on Balalo must trace its origin from the meaning of the word itself. The term, as we all know it, was first constructed to connote settlers as opposed to natives, and has increasingly become a derogatory label that implies backward and stranger. It's widely believed that the term Balalo comes from the Luganda word meaning mulalo, meaning backwardness, stranger who does not assimilate. The Balalo label once primarily referred to the group's common cattle-keeping occupation. However, the settled community's negative reaction to their migratory lifestyle shifted the label to foremost connote backwardness and stranger. These contingent constructs were superimposed on the Balalo as a reductive label that framed their identity in opposition to settled farmers. But let me also highlight that the Balalo, as we know them, are comprised of many ethnic groups. Yet history shows that they are actually a product of the history of the state creation in Uganda and East Africa. History shows that pastoralists migrating from the north as far as Egypt and Ethiopia settled in the Interlacustrian region, including modern Uganda. Parallel movements of communities with common language and cattle-keeping traditions have been taking place in modern-day Rwanda, Uganda, Burundi, and DRC. The creation of Uganda, a Uganda protectorate, resulted in a diverse array of kingdoms and communities being grouped within an imposed border. And there was a subsequent redrawing of regional borders that affected cattle corridors, including in Uganda. Additionally, and I think people have already said this, the creation of political statehood in terms of the modern day government resulted in the transformation of the common pool cattle corridors into national parks and private property, including ranches, and is seen as directly linked to the Balalo perpetual displacement and movement. I think it's important to understand that historical location of the Balalo, that actually these people have been here, but several things happened as we are constituting the state of Uganda. But again, as the state begins to take over, we begin to see that the state has its own differences and interests. One such example, which I will point out, is the local settled community across Uganda, of course, have voiced opposition to Balaro as a result of their movement of the cattle corridors. But also the government itself. We all recall that in 2018, the government evicted several hundreds of Balaro families with about 20,000 heads of cattle from Bulisa districts to make way for petroleum exploration. I hope you remember that. The government claimed that the Balaro were trespassing and had illegally bought indigenous land, in addition to causing grief and security concerns. The government affirmed the customary claims to land of the indigenous communities and urged the Balaro to leave, whether or not they had lawfully purchased the land they were claiming. The 2018 evictions intended to combat retrogressive nomadism, but they only succeeded in sending the Balaro into perpetual motion across the country, drastically increasing tensions wherever they landed, including in northern Uganda, where the issue is most loud today. But the question is, where they have landed, and in terms of the constitutional promise, because we are here discussing this Balalo issue in light of the 30th anniversary of the Constitution. What does the Constitution say about such matters? I want to start by saying that the Balalo issue or presence where they moved, particularly in Acholi and Lango sub-regions, where I have spent a lot of time studying, has steered very deep conflicts over land ownership and use. The Balaro are being accused of many things. One, illegal land acquisition, fencing of communal grazing fields, crop destruction, and blocked access to rivers. There is a very strong feeling that the unchecked Balalo influx threatens not only land ownership systems, but security and social cohesion. In terms of land, we start from the Constitution. The Constitution says, Article 237, that land belongs to the citizen of Uganda, and they shall vest in them in accordance with the land tenure systems provided. And these land tenure systems are freehold, Customary, Milo, and leasehold. Very good. But where the Balalo have settled, the contestation is about the communal nature of the land where they have gone. Especially in Acholi, land is not merely a commodity, but a cultural repository and a livelihood foundation. So the question is, how do you settle in such a community? Do you just acquire land using the torrent system, or you anchor yourself on the cultural path of the community? And I think this is the conversation that both the earlier speakers have alluded to. As a nation, we seem not to understand each other. And even when we have a constitution that provides for customary tenure, the mode of interaction between the citizens and the state that is supposed to facilitate this is incongruent. And as a result of this incongruence, you begin to see a lot of tension, which if not well articulated and addressed, they will definitely lead to wider problems. And how does the state respond to the Balalo issues? Through executive orders. I have put all this detailed in my paper. I am not going to read it word by word, but I'm just going to emphasize to generate a discussion and a response. Two executive orders, Executive Order number 1 of 2025 and Executive Order number 3 of 2023, issued in May 2023, and the latest one, number 2 of 2022, issued in June. Now, when you juxtapose these executive orders, the Constitution and court decisions, you sort of sympathize with the president that is coming from a good place, given the concerns raised by local communities up north, particularly in Acholi and Lango sub-regions. Nonetheless, my view is that the executive orders already must be construed within the constitutional framework and the legal framework. And we had opportunity. I've spent a lot of time doing a lot of litigation around customary land tenure. And for me, it's very important because just like Dr. Kavumba, who wrote a very good paper on black law matters that he delivered, I think 2023, Ben Kiwanuka lecture, which I invite you to read. We need to think very deeply about how we understand the constitutional promises and then how we lawyers articulate them in the work we do. And the missing link has been across. You look at these executive orders, they don't articulate the promise of a customary land owner in the Constitution. The courts prior to that, and the Land Act itself, all were missing in terms of details on unpacking the promise of the Constitution to the people who want to own land under customary tenure. I give you an example that led me to go to Constitutional Court. The case of, which I've again provided in this paper. Madvani wanted some land to grow sugarcane in Amuru. So what does he do? He applies to the Amuru District Land Board. Amuru District Land Board construes itself as the owner of former public land. You remember before that, land was all public land. So meaning that the people who had left those areas in the 70s for various reasons their land was taken over by the district land boards on basis that it was former public land. But the CA, while enacting customary tenure, was very clear in its design that this tenure and the land we are giving it back to people to address historical wrongs that the colonialists had left in form of the Constitution and the land laws and successive governments. So we see the court of law, this matter went to court, and this is what the judge says. The judge said he delivered this judgment on February 2nd, 2012. I still write it there in my presentation because it was just one day after my birthday and it ruined my birthday. And he said, the land in question, he agreed with the giving of this land on the basis that's public land. And this is what he said, that the land in question was once a gazetted game reserve, but it was gazetted in 1972 and later converted into public land managed by the Uganda Land Commission. Subsequently, it was transferred to the Amuru District Land Board following the promulgation of the Constitution in 1995 and the enactment of the Land Act of 1998 by Parliament. Then he went on to say, since this was a public land under the jurisdiction of Amuru Land Board, the first respondent, who is Amuru District Land Board, was right in granting it to Amuru, Sugar Works, and all the other people. And this caused a revolt where I was seated, because the Constitution had made the promise that take back this land to people from the time the colonialists dispossessed them. And here was a high court saying that since this was former land, by law, an act of 1974, the Idi Amin Decree on land, we therefore agree that these people rightfully can allocate this land. So I thought about what to do, and I persuaded some senior citizens then to file a constitutional petition. And we worked on that petition. It was quite some work. And it was a tall order to persuade the Constitutional Court to agree in the Justice Galdino Okello Court, Omoro case, which had very many people, to agree that while looking at land matters in that area, go back to the pre-colonial times and begin to engage with the citizens based on that time, meaning that whatever happened between that time and 1994, you had to look at it with new lenses. And that's the judgment. And I'm saying that, unfortunately, the executive orders, the management of the current Balalo issue is missing out this very fundamental thesis that was well articulated in the Constitutional Court. And that is why I'm so happy with this topic of transitional justice. We need to go back to the conversation. If the court has said that, go back, begin to trace ownership from pre-colonial, isn't that restoration? What that does mean, that the state must begin to think and have a conversation with the people based on that. So when the Balalo issue comes, it comes, unfortunately, in the mix of all these things. And people come to acquire land in many ways. And when they acquire this land, they acquire it very cheaply, number one. Number two, they then use the torrent system to justify that. But again, this is the problem with us lawyers. We are so lazy that what we think about today is Torrens, Robert Torrens from Australia. We have not done the work, Dr. Tusasirwe, in breathing life in our native systems. And we are all as guilty as charged. The law schools are guilty. Senior counsel, guilty. The lawyers, guilty. The law students, first-time offenders, okay? First-time offenders will discharge you with the warning that you have to do a lot more work to begin to breathe life into this constitutional promise of customary land and ownership. Now, let me say something about the Balalo. Is all lost on the Balalo? Not at all. The Balalo are equally a displaced people by the post-colonial state. I have landed on some very interesting work and a map, which I think, you see the Balalo have traditionally traveled across a corridor. They call it the cattle corridor. Those who are older would understand. Seeking pasture. The formation of the state-introduced regulatory frameworks for land ownership, both private and public, that did not align with the nomadic way of life. So what we see that those cattle corridors were made public lands and designated as parks and forests. And I've already given an example. Some activities like oil pushed some of this Balalo off the cattle corridor. And because they no longer have where to go, they find themselves in other communities. But again, the state has not addressed that Mulalo who used to walk in this cattle corridor. I found a map. This was the corridor. If you see this corridor, Dr. Kavumba, you see in the north here, it was not a cattle corridor. They had a specific corridor along water and all that. And pre-colonial, they coexisted. Like I have told you, tracing their origin, they came from far, Egypt and all these places settled. They had a cattle corridor. But they were also dispossessed. So we have a Mulalo who has been dispossessed, looking for a solution. But also, you have a Mulalo, and Dr. Komakech writes about this. He says, and I quote, "Decades of significant land privatization and government seizure have increasingly encroached on the common lands and this has made nomadic families very vulnerable." So you have on one end that the real original Mulalo, who should have been catered for by the state, has also been dispossessed. So what does he do? He moves to another place, encroaching on other land and causing a lot of damage. But also beyond that traditional Mulalo, in my paper, I make the point that there is duality now. There is also a Mulalo who is not original, but he calls himself a Mulalo. This Mulalo, you remember when you look at the executive order of the president, you see how he defines the Mulalo. But the Mulalo existing again also today within this mix is another Mulalo who, in my considered opinion, is beyond the reasonable person test that Justice Kakuru has propounded in one of his judgments, where he said the person, a reasonable person, is one who attends to their farming or other duties, probably owns a motorcycle, listens to radio, takes their children to school. He says that's a fair test of a reasonable person. But there is another Mulalo today who is beyond this test. You get it? He is influential. He owns thousands of acres of land in northern Uganda. and he has land titles for them, and he also has his cows guarded by AK-47 rifles. That cannot be an ordinary what? Mulalo. This is what is causing significant concern because of the potential or the land grab that has come from this exotic Mulalo, who calls shots, who is very, very, very powerful. So we have those two issues that we must juxtapose. The original Mulalo was dispossessed, went somewhere causing tension, but perhaps that could have been handled through a conversation. Then there is another Mulalo who calls himself a Mulalo, but he's very powerful. His cows are guarded by rifles, and he owns thousands of land. So I will return to say that in looking at this matter, it's essential that we explore and unpack the mindsets of this. And this is where the problem is. Part of it is that the modern state is not addressing the real issues. Okay? It's not addressing the issue of the pandering Mulalo, but also is the state being fair in protecting the rights of indigenous landowners. And that's where I have a problem, because we have argued this decision, the Constitutional Court has resolved it, so we are now essentially dealing with the rule of law problem, that the state is unable to implement this decision in the manner desired, thus leaving in its wake dispossessed people over land. The state is also not bringing into place sufficient legislation to actualize the rights of the landowners in northern Uganda. The Land Act, as far as customary tenure is concerned, was more driven by the desire to commodify land. You get it? The framers of the Land Act were more interested in how do we make land in Uganda titled so that people can mortgage it, people can sell it. They forgot to think about the communities and how they relate to land. Land in northern Uganda is not sold in the manner that land under the Torrens system is sold. Land in northern Uganda is owned by a community. So for you to deal with that land, you are not dealing with one person, you are dealing with a community. So what does the Land Act do? The Land Act is framed without sensitivity to the owners of customary land in northern Uganda. And that is why it has failed in that regard. When you look for just one example, how it treats traditional leaders, it says that traditional leaders may be consulted on matters of land, meaning that they are not obligated to be consulted. And the moment you miss traditional leaders in matters of customary land in northern Uganda, you have effectively moved towards unlawful dispossession of land. So I want to say there is a law to operationalize the Constitution, not well thought out, but who drafted it? Lawyers, right? Did black law matter to them? Did black law matter to them? It didn't. Now, beyond, let me conclude by saying beyond this Balalo issue, I want to make the following. To say that the Balalo claim predates the modern state of Uganda, yet they have been categorized as unwanted outsiders by government, media, and general population. The Balalo therefore engage in a precarious coexistence with host communities as they tentatively arrange a truce, remain aloof from the local inhabitants, and eventually accept their inevitable removal. Nonetheless, I submit that any legal response to the Balalo issue, in my view, is already reflected in the interpretation of the Constitution and law by the Constitutional Court in the Justice Galdino Okello case. My urge is that anything to do with Balalo or land acquisition in the north must oblige by the guidance given by the Constitutional Court. After all, in my understanding, that is what the rule of law is, that if the court has pronounced itself on a matter, then we are all called upon to implement. But beyond implementation of this judgment, I am also saying there is a pressing need to implement transitional justice and reconstitute the entire state framework. The ongoing Balalo crisis exemplifies the need for a transitional justice approach that addresses historical injustices, cultural rights, and socio-economic marginalization. There is a need to urgently operationalize the national transitional justice policy in terms of synergies between formal justice and informal justice system, including supporting what Dr. Ojara said, proper nation building and reconciliation, reparation for land injustice, and so on. But I've already highlighted laws like the Land Act must be reformed to once again foster confidence in the legal system. I'm also proposing in my paper that this issue of Balalo must be considered more deeply. They must be given a voice. Their rights must be respected, and we go back to the cattle corridor. What happened when they were dispossessed of their rights in that cattle corridor? What should a state that is sensitive to the rights of people should have done? We need to interrogate that matter. But I'm also saying that to prevent future land-related conflicts, we need to listen to each other more. The communities must be brought back to the conversation about how they want land governance to be undertaken. But perhaps more importantly, we need to reconstitute the state. We need to reconstitute the state. We need this conversation. And I think Dr. Tusasira said it in better words than I can ever put it. And if you read the Monitor today, one Dr. Businje Kavumba, I quote him, this is what he says, that we are still searching for national consensus, and that search is being postponed by government based on military rule, in which a group of people think they can determine the destiny of the country that is keeping hostage several organic entities, including whether it is the kingdom areas. But just as the British failed to do it, they have it, and once in a while, you have manifestations of this. Some call it the Balalo, but these are just manifestations of one problem. And this is the problem one Dr. Kavumba says. The question of people who have not had an opportunity to have a national settlement that is fair to everyone. I conclude by saying that we need, as a matter of urgency, to establish new standards for upholding the rule of law and ensuring good governance in the country. I have already said and cited several authorities to make the point that many times judicial interventions may have provided solutions, but they have not addressed systemic changes that are necessary to deliver the rights that people expect. I've given the example of the Galdino case, but I've also told you that the Land Act is very faulty in the way it represents the constitutional aspirations of people who own land under customary tenure. Therefore, what do we need to do? We need to understand that the country is in different stages of conflict. That's what the Balalo thing is telling us, that we are in conflict, but in different stages, and the conflict is in very different parts. But the starting point for me would be, let's think about a national dialogue very, very seriously. And I don't want us to think about a prescriptive national dialogue. We need a national dialogue which has a national healing and reconciliation framework. This dialogue must be nationally owned, it must be non-partisan, but it is aimed at restoring civic trust, confronting the past, and fostering a shared vision for the future. And there are some pillars I would like us to think about. There must be truth-telling. These historical matters must be interrogated. There must be forgiveness and healing. And in that, some communities have led the way in demonstrating what restorative justice can be done. It's important we think in those terms. There must be institutional reforms in terms of legal reforms that prevent future abuses. And lastly, the young people must be included. Okay? Youth inclusion and empowerment. Like we are doing today, we are telling you we have done a terrible job in advancing black law. We are empowering you to be able to advance black law and do a better job than all of us. In conclusion, I submit that the Balalo question is more than just a land dispute. It symbolizes significant, broader national questions about identity, state authority, land rights, and social justice. And it is true for both the Balalo, like I've demonstrated, and the indigenous communities where they have moved to. Thank you so much for listening to me.
Thank you so much to our keynote speaker. I would like to use this opportunity to also recognize one of our guests, Dr. Ntando Ndlovu, who is with us here. He's visiting from the University of Fort Hare in South Africa. And I look forward to hearing what his views are on some of the submissions that have been made and if there are certain comparisons that can be drawn from their experience as a country. I also want to, okay, so a lot of questions have been asked by our previous speakers. We've had them. Some solutions have been offered, a lot of solutions rather have been offered by them. But in response to the keynote address, I would like to invite, not yet, but to introduce, Honorable John Ken Luchamzi, the man who will respond to the keynote address. Honorable John Ken Luchamuzi is a leading politician and a lawyer. And aside from his distinguished service in the 7th and the 9th Parliament of Uganda, he has also published books, several. Okay, two books. He's published 2 books, and there is one more in the pipeline that you should be looking out for. One of these books is Uganda, A Creature of the Federal Doctrine. So, Honorable John Ken Luchamuzi is an international fellow in federal studies, and he has been a keen and consistent thinker around federalism, and he has been advocating for a federal system of governance in Uganda. For a good number of you, you will remember from the early 2000s, federal, federal, federal. This is a tune that he has sung for years now, and I would like us to put our hands together to welcome him as he responds to the keynote address.
Independence, allow me to donate to you a poem off the cuff in that order, titled Uganda is Paradise. And being a past student of literature at St. Andrews College, Kitovu, I am excited to see some of you who may have come from that school. When I was here as a student, I was so much fascinated by the teaching of Dr. Kusasira. And I still remember the tones of a great case titled London Properties versus ITRIS. And whenever I have an argument to make in the countryside where there are scholars, sometimes I draw their attention to the ruling of Lord Denning as an obiter dictum. The poem goes as follows. Uganda is a land of the sun. It is a land of the leopards. It is a land of the gorillas. It is a land of freedom. At the Makshan Falls, when the waters flow, the lions roar, the giraffes yawn, and the rains fall. Uganda is a nation of many nations, with a rich mosaic of cultures and languages found nowhere else in Africa. There are Arur, Pukot, Abanyankole, Abachiga. They are also kings, great kings, paramount kings. Emorimori, Omukuka, Adora, Obusinga, Kyabazinga, Ruoti, Omukama of Toro, Mukama of Bunyoro. In Buganda, the Kabaka reigns, he does not rule, but he still commands. There are also birds, the singing birds, the flying birds, the African skimmer, the shoe-bill stork, the fish eagle, the crested crane. What about the trees on which you feed, without which you have no oxygen? Ficus nantalensis, Grevillea robusta, croton, acacia, Kaffir robusta, emwanyi. Thank you very much. I have listened very carefully the words of a distinguished scholar in law, and I admire what he has said. Without prejudice, he narrates the story of the Bararo very appropriately. The missing link is what must we do now? When he talks about a dialogue, how many people of high rank in Uganda can respect dialogues? Eventually, you go into the dialogue. Yes, you talk, and you talk out yourself. He will score the day. So I have come with a proposal, with a concrete proposal to make things take off. I concur with Dr. Gimara, Mr. Gimara, but the Bararo conception is very dubious. First of all, in Uganda, if we don't work out a solution about the Bararo, we are under invasion. There are 20,000 refugees in Uganda. 2 million? Yeah. Refugees? Yeah. There are 2 million refugees in Uganda. Now, when you talk about the Bararo, how many Bararo are Ugandans? How many are not Ugandans? Why should a responsible Ugandan not be concerned about that state of affairs? I have a problem because under a situation where the top leaders exercise their powers the way they want, what do you expect? The president in Uganda can do anything. We are in trouble not because we should not be in trouble. The man is exercising unchecked orders. What can you command under dialogue, Mr. Gimara? I have looked at the Bararo situation under 3 covers. There is the Buganda question, which could also cause a problem if we don't attend to it. You have the Bunyoro question. You have the Karamoja question. In Karamoja, it is on record that the late Sir Edward Mutesa used to donate his salary to the people of Karamoja because they were poor, but they are still poor. As we speak now, they are exploited by the top leaders. They have a rich score of minerals, very indispensable minerals. Are they getting any money from the minerals? The current government takes investors to Karamoja. They dig down for the minerals, sell the minerals. The money is not recorded in the consolidated fund. It enriches those rich people in government. And can you say that Karamoja is poor? There must be a solution which could solve and divert that situation. You have the case of the Bunyoro question. I am told that the president of this country does not want anybody to talk about federalism. To hell with him. Why? Has he got the power to command the citizens of Uganda that own power to do what they must do? They must not do. Why, if he does, he's hiding under the sand. Why is he naming a minister in charge of Luero, a minister in charge of Bunyoro, a minister in charge of Karamoja, a minister in charge of northern Uganda, a minister in charge of Teso? What does that mean? Fooling the Ugandans. You have the question of Bunyoro, the Bunyoro question. I was recently in the Bunyoro on the campaigning trail because my party is participating at the presidential candidacy level. And I was given a warm welcome. People did not want me to leave the platform when I started talking. I told the people of Bunyoro that oil can become a curse. First of all, the ground under which it is in existence is very fertile. It harbors Maxon Falls National Park. There are 130 oil wells in the national park. That national park the wells have direct connection with Lake Albert, Lake George, and Lake Victoria. If you cause any chemical catastrophe, the consumers of the waters of those bodies can be in trouble. So the agricultural practice in Bunyoro can collapse imminently if no attention is paid to the exploration of that oil. As we speak now, under the Constitution of Uganda, there is no given guarantee that the Bunyoro will get any meaningful royalty out of the oil. It will be peanut. Why should they receive peanut when they are risking the fumes of petroleum? So, Mr. Gimara, the solution in that direction would be Uganda should not go to Museveni and say we need a federal government. No. Action under action. The Conservative Party has proposed a petition seeking to amend the regional government provisions of the Constitution. So you send us able-bodied members of parliament to join me in the next parliament so that we conquer the problem. What we want to essentially do is as simple as this. We are going to propose that the name Republic of Uganda is too narrow to accommodate our interests. We have gone through an adventure of history which calls for us to recall what we were before Bote dismantled us through the ex parte Matovu case. You all know that ex parte Matovu is the ex parte case in law is not a judgment. If you read the latest book of Musa Sekana, he says an ex parte judgment is not a judgment. Why is he saying that? Because even by now, after 63 years of independence, Ugandans who are aggrieved can still appeal the ex parte Matovu case up to the International Court of Justice, and we would win. So, what are we saying? Look at the worker plan of that law, the regional tier law. Dr. Kabumba, you must have read it very carefully. It is disastrous. They create a situation where the district is seemingly competing with the region. The region and the district must have one goal, one focus. So we are proposing that the name should be changed to Federal Republic of Uganda. Because when the nation was starting at birth, we all agreed summarily that because we did not want Buganda to isolate the rest of the regions, let us develop a principle called federalism, a federal constitution, so that we are all accommodated. Federalism does not depend on size. It evolves circumstantially. It can exist due to the powers of economics, the ethnic groupings, the population. You people in Uganda should not sleep and see this Museveni fooling you. You have every power to adjust the point to where you want to go, and the time is now. Now, in terms of what Mr. Gimara referred to as the customary law, some of you know that the Land Act of 2004 is a baby of John Kennedy Richards. I had proposed some fundamental issues which could have rescued this country. But as soon as Museveni saw me go out, he changed the law. And this. Now, I don't agree with Mr. Museveni. He is supposed to be the custodian of the Constitution, and is doing the opposite of the Constitution. For example, I really find difficulties in getting this man to understand that the law is above him. In the case of Justice Okero Omoro, versus the Attorney General. The ruling came before Museveni issued the presidential directive. That is an absurdity. A whole president of a country who is the custodian of the Constitution should know the Constitution ahead of the other people. So I think that the phenomenon of the presidential directive in law needs revision. First of all, under Article 98, 99, if the president wants to exercise his presidential directives, he should get Parliament to operationalize the contents of 98 and 99. Otherwise, what is now issuing in terms of presidential directives is no law at all. Anybody can crucify me under that statement. Now, what should we do in the circumstances where there is confusion and people do not know what is happening? I think the following should be done. Let Ugandans organize themselves. Send appropriate people in Parliament who will move a motion to amend Article 178, Article 176, Article 5 of the Constitution. Article 176 of the Constitution is an absurdity. I don't know why the draftsy people drafted it in that way. As we speak, Uganda should be governed under the regions. You cannot put a regional tier and then you also carry a statement of that kind. And Mr. Gimala, being a senior lawyer, should adventure into correcting the error through the Uganda Law Society. Uganda Law Society is also thanked. I'm very grateful for the award they gave me. You did not read about it in my notes, but I was awarded for excellence, for the excellent work in parliamentary practice on human rights. So the issue of saying we go to Museveni at way federal, that is nonsense. Under Article 1 of the Constitution, power belongs to the people. How you exercise that power is your business, not President Museveni. Parliament has let us down. I'm sorry. I'm not saying this because I'm not there. But I think I left some legacy in Uganda's parliament. Even if we have a few people who understand what we are up to, things should improve. For example, now, we are going into an election in very dubious circumstances. The Supreme Court issued orders that A, B, C, D must be taken to Parliament to refine the electoral laws. One of them is, number one, remove military from elections. Has anybody done anything? Don't we have opposition members? They are silent, they are eating. I don't understand. How can you go into the election, tell people we must win Museveni? How can you win when you have that kind of parameter? We are in trouble. This country needs rescuing, and you young people don't sit on yourselves. But I am also commending the educated youth. You are, of course, educated. You have not fumbled to support things the way anybody would. You are checking your steps, and that is very good. You are creating a good example. When I was here at the law school, I remember, I think Dr. Kabumba and Dr. Kutasira would recall, many students were fond of letting me read cases. I don't know why. When the lecturer said, who is going to read this and this, some of them pulled their hands down, only to leave mine up. Because maybe they were interested in the way I serialized the issues. So in the Balalo scenario, you have the following problems as I end. Uganda is becoming too expensive to manage. Corruption and the dubiousness are eating up the moral fiber of leadership. Government standards are dwindling at an alarming rate, and something must be done. If you are dominating the population in terms of numbers, the educated young people like you should lead the course of action. Don't stay aside. Advise those who are in the channel of action so that they engineer greater works capable of fighting a leadership catastrophe. Anything can happen. Under the current circumstances, another Idi Amin may come anytime now. We don't want to go back to the bush. What do we do? And we cannot be stagnant. And the money is not going away soon. So what do? Do something circumstantially so that you rescue the power of Africa.
Thank you for your response, Honorable. I would like to invite Dr. Ndlovu to intervene for just about 5 minutes. We are running short of time, but about 5 minutes should be sufficient.
Good afternoon. I stand on all existing protocols for the purpose of time, but I must say that we have felt at home for the past, I think, few days that we've been here under the capable leadership of Dr. BK. Without wasting time, I think this is a continuation of the discussion that I had yesterday with first years, particularly in this hall. But I'm going to share briefly from the South African experience, but also taking into account what was discussed here. These are not Ugandan questions. They are questions we are facing as a continent. I think that we should get clear. And three things, in fact, emanated when I was sitting there. Number one, that history matters, politics matters, and law matters. I think when the guest lecture was being given here, the end and the first of it was that everything must start and end with the Constitution. In any rule of law state, we should start and end with the Constitution. I said to the first yesterday that the Constitution is not a perfect document, but it allows us and gives us an idea as to where we come from and the society we aspire to be. So once we deviate from the Constitution, and sometimes we create anarchy and problems, and I think that is what is coming from the floor. Now, in South Africa, we've got a land issue which is very thorny. You might have seen our president in the US. It emanated all because of a land question and some lies and misinformation being peddled on the screens that you see. That is a white genocide. We don't have anything of that. Some of those images are not even from SA. We don't know where they're from. In fact, all of them. Now, land disposition happened in South Africa because of history, similar to what happened in Uganda. So currently, land is in the hands of the few whites, right? They are South Africans, they are Africans, they are part of us. Similar to what I think was delivered by Doc, that President Mandela created this society. But now the question goes back as to then how do we ensure substantive equality in terms of accessibility to land? That everyone, including dispossessed Black Africans, have got access to land, not only to farm, but to build houses, to build industries, like to make something out of it. I think that is where we are. But our constitution has got a caveat because it talks about redistribution of land with compensation. And I think that is where our national question currently is at. And we recently enacted a law that perhaps the West is not happy about, that allows perhaps to some extent the government to take land and redistribute it accordingly. But part of the similarity or common denominator with the discussions here is that, number one, at the center of it should be public participation. The affected communities, whether it is in Palalo, whether it is anywhere, we should allow the communities, what are they saying about this question? So we shouldn't have solutions we impose on them, but we should allow them to be part of the discussions. If you look at what's currently happening in Madagascar and in Kenya, definitely what Honorable was saying now speaks to me and you. We need to be part of the discussions as to how a nation is governed, how a nation is run. Because then it allows, the solutions to be, informed about the affected communities. So, the Palalo question, maybe similar to the South African question, is that they need to be an equivalent of allowing both the affected indigenous persons as well as the Palalo people, to sit with government and with traditional leaders, religious leaders, and every other stakeholder involved. Where to from here? How do we move forward beyond the Constitutional Court decision? As a rule of law state, we should be guided by the Constitution more than any other thing. That will allow for order, I think, in society. Because like you are saying, I think the problem of the Palalo, as I read it, and then briefly, I don't know much, is that it is beyond just the borders of Uganda. It is across the region because of the movement and the migration of persons. But I think how we fail is that we fail to accommodate the Palalo people, because we are this one nation that sort of exclude or overlook normativity or nomads in a state. Now, where do they go? Where do we put them? Then it becomes an issue that there need to be a solution specifically to say, let's accommodate equally so this particular population. Earlier it was asked here, are they Ugandan citizens? Are they non-citizens? I don't use the word foreigner in my language. I don't use alien like Trump. I use non-citizen, non-local. Those are legitimate terms. Something foreign, something unwanted. Something alien, something unwanted. In society, in human rights language, a non-citizen sounds okay, non-local, But now, complicating this question again becomes the issue of intercultural marriages between Palalo and others. Then how, at the end of the day, you may not be able to identify that this is a Palalo person because there have been intercultural marriages, there have been, perhaps other complications that may not necessarily allow you to find this is a Palalo person and this is not. Now, beyond that, I think a clear example was given of Tanzania. You'll never hear Tanzanians speak of ethnicity. At home, we've got Zulus. My dad was Zulu. Sandla comes from a Xhosa tribe and whatnot. But in Tanzania, they are Tanzanian. It ends there, nothing else. It doesn't go beyond that. So now we need to, part of it is tolerance, that we accept the Palalo people as Ugandan people. I was saying to the first years yesterday that I was in a PSC meeting in Tanzania. One of the things I learned is that Uganda hosts a lot of refugees. They say 2 million. It shows that you've got the capacity and perhaps the idea of diversity and tolerating people from different places. That alone is a good step that can allow you to answer some national questions because you are a society by nature that tolerate others. And I think on that note, I'm going to leave it here. Thank you so much.
Dr. Ndlovu, I would like to just invite you back here for a few minutes as Honorable John Ken Luchamzi is so impressed by your submission that he has a gift for you. So yeah, just take it. So that's a copy of the book that I mentioned before, Uganda, A Creature of the Federal Doctrine. It's a good book. You should all read it. So I'm going to open up the plenary now. It has actually been opened up by Dr. Ndlovu, but yeah, I'm going to open it up to the rest of us now. We'll do maybe 10 minutes maximum. We'll just take a few. 20. Okay, he says 20. Okay. I will start with not Dr. Busingye. Who's going to help me move the thing? Where is the mic? Okay. No, it should be the second.
Thank you. Thank you so much. My name is Aloikin Praise Opoloje. I'm a human rights activist, and I have had, I wouldn't call it, the unfortunate privilege to organize and mobilize Ugandans for a number of protests that we have had, like March Parliament, pushing for the Kabaziguruka judgment and stuff like that. My question is to Honorable Luchamuzi. You talked about organizing people for change, to push people to Parliament, and you hinted on something about nonviolence, how we don't need another gun scandal. However, from the little experience that I've had organizing, with the increase in militarization in this country, how can we hope for a transition, for a better country, to build that state that we want without the conflict of guns? Yeah.
Thank you. My name is Godwin Toko. So I have just two simple questions. The first one is, Mr. Gimara hinted on this. The issue of the ordinary Balaro and he called them the fake Balaro. So I grew up in northern Uganda, in West Nile to be exact. Unlike you, I crossed the Nile twice, at Karuma and then Pakwach. So what I noticed is that from the time I was a child, my family was supplied milk by a Mularo man. So this man has basically lived there for what, 25 years maybe, at least, if I take that as a gauge. Then the thing that you raised about the ordinary and the new breed of the Balaro, Nicholas Opio famously talked about them. He even mentioned names, and some of them are army generals and all that. How do we address this question without hurting, injuring the other ordinary Balaro who have lived in northern Uganda all their lives? Because some of them have actually been there for that long. And finally, so there is a book I'm reading by Yusuf Serunkuma. What Yusuf does is locate the empire, the West, in all these problems that we have. The Balaro question seems one of the many land points in Acholi or northern Uganda. You have a similar question with the PA. People have been killed. You have a similar question between, I think it's Ngor, is that not, Pakwach, somewhere around Pakwach. So we know for a fact that northern Uganda is said to have Acholi, perhaps one of the most fertile lands. Someone said it could feed the whole of the East African region if utilized well. We know that there are South African farms there, big South African farms farming on hundreds of hectares of land. We know for a fact that now there's sugarcane plantation. So where is the empire in this? Could someone be setting up us against each other as ordinary Ugandans and black people, and yet they are doing the dirty work behind the scenes to steer this kind of conflict? Thank you.
Thank you very much. I really didn't want to speak, but just a minute. One is, I think it's a comment. It came from the keynote. I think the reference to history, and the point that John Ken made, and also Dr. Ndlovu. I think the question of history is critical. And linked to that, then is Article 32. I think it's an underexplored provision of our Constitution, because that's the one article that talks about historical injustice and the need to redress historical injustices. And technically, that may be a provision that allows for us to go around the limitation in civil procedure that we'll talk about 12 years, for instance. I think there was a decision from Kenya, I forget the court found for the Batwa, but under Article 32, then sent the case to High Court. But Dodge court found for the Batwa, but under Article 32, then sent the case to High Court, but dodged the question of indigenous groups completely. So it's something, I think, for us to explore in terms of how history can inform constitution making. Now the question. And John Ken, this is related to the discussion we had when we were celebrating or commemorating the 32nd anniversary of the coronation of the Kabaka. It's a challenge I posed to the group there, and I want to pose it to you again today, as I also pose a challenge to Francis. And it's this. Now, Francis, the Galdino case says, let's go to the pre-colonial time. Now, Makerere University sits on land that was leased from the Kingdom of Buganda. I think actually at some point there was a threat that Buganda wanted the university land back. Now, for me it is this. There has perhaps to be a give and a take. So if land in northern Uganda must be communally owned, perhaps to the exclusion of, this Hyde versus Hyde, to the exclusion of all others, perhaps. But at the same time, we are here in Buganda. And Buganda Kingdom lost the attachment to land in the case of Mwenge versus Migade, where land was declared that it could be alienated. So Buganda has given up something. So if Buganda has given up, shouldn't Northern Uganda also be ready to give up something, including land, as part of the give and take to constitute this Uganda? That's a challenge for you, Francis. But now for you, John Ken. If Buganda is, among other communities, is making the case for a federal state, or federalism, how will you then respond to demands for self-determination from other groups, such as Kochi, the lost counties? So again, the give and take. Should the same rule not apply, and how then can those contestations be resolved? Thank you very much.
Can I ask a question? Mine is a question to the keynote speaker and the respondent about to what extent is the Balalo question a case of weaponization of identity by hegemony or hegemonistic framework, and correlatively disenfranchisement through disempowerment of some communities? Thank you.
Yes, thank you very much. My name is Katende John Baptiste. I'm a third-year law student and the current vice president of the Makerere Mood Society. Mine is a compliment to both the keynote speaker and the respondent. I've had a benefit of being nurtured by Honorable Ken Luchamuzi. Honorable, I'm not entirely sure whether you still remember my face, but just to remind you briefly, I met you last year and I introduced myself as your fellow old boy from St. Henry's College, Chitovu. And I also had the benefit of being hosted by you at your residence in Rubaga, Mutundwe. And I really benefited from the conversation that we had. And I can say for a fact that you did not only stop at nurturing me, but you also contributed to the passing of my evidence examinations, because upon that visit, when I was hosted by Honorable Ken Luchamuzi, he gave me a gift, and that gift was in form of a textbook, The Law of Evidence by Ian Dennis, which I have seriously cited in my examinations and excelled. And for the keynote speaker, Mr. Senior Counsel Gimara, I had the privilege of attending the 8th memorial lecture of Honorable Benedicto Chiwanuka, and I have to say that I really benefited from the keynote address that you gave in that lecture. Now, my question is not for the panel. It is to the administration, and since Dr. Benson and Dr. Kavumba are here, I just would like to briefly bring this to their attention. Now, when you look at that statement, it states that your future starts here. Now, taking cognizance of that statement, as lawyers, we are supposed to specialize. We all have fields of interest we would want to specialize in. However, those fields of interest are facilitated by the electives we choose in our third year of study. At the start of the semester, we thought that we had the option of choosing any elective that we wanted. However, 4 weeks into the semester, we received a notice from the administration stating that students were not, it was not appropriate for the students to offer course units whose time allocation on the timetable is the same. However, this was 4 weeks. We had already started attending the lectures, and this was near coursework week. I and some other numerous aggrieved students, we went to I will not say the office, the administrative office, but I can assure you, when we raised that matter, we were chased out like chicken thieves. We were not given an opportunity of being heard. However, we referred the matter to Professor Buyinza Mukadasi, who is the academic registrar, and he issued a notice. However, in that notice, he sided with us, and he said that he still refers the matter back to the administration to issue down a final resolution. And that resolution was supposed to be handed down on Monday last week before we would do our courseworks. However, we waited for that resolution from the administration. Up to now, we are still waiting for the resolution. So some of us had to do 6 courseworks. We're supposed to do 5 course units, but we had to do 6 courseworks, which is actually penalized, but we had to. So my request is, I kindly request the administration to provide clarity, because we interacted with the registrar here, Mr. Laban, and he told us that it is okay at the moment, and he said that enforcement of that principle will start next year. However, we are asking for clarity from the administration. Thank you very much.
Thank you. My request is that the next people just be as succinct as possible. We'll do maybe, I see 1, 2, 3 hands. That just a few seconds, yeah.
Okay, thank you very much. My name is Etiang Jenkins Stephen. My question goes to Honorable. Right, apparently, as a country, one of the main reasons as to why our constitution is being altered with here and there is because of the monetarization of politics in the country. And you realize that the reason as to why NRM is dominant is because there is a lot of money that has been invested, and voting in Uganda today is like a trade. You give me, I give you the vote. So how do we go about this aspect? Thank you.
The gentleman in gray, the gray shirt.
Thank you so much. My name is Lagen Peter. I want to put, I have 2 comments before I ask questions. One, the issue with customary tenure goes deeper into the aspect of the identity of the people. I have 2 points to blame. One, what Senior Counsel Kimara said about how the Land Act has marginalized the customary tenure system. You go to Land Act, you find that the Land Act does not say customary tenure is a creation of the constitutions, yet other tenures are creations of the constitutions. That was the loopholes, and how customary tenure is dictated to be governed by the local customs and norms, yet the traditional people are not involved in the system. 2 point, the second thing is about the aspect of the politicizations of the Balalo questions. What Dr. Kabomba has just said, it goes politicizations and ethnicizations also. There's the aspect of ethnic identity. But if we are to ask ourselves, who are the Balalos? Are they the Banyarwandas? You realize that these Balalos people are not a specific ethnic group of people. But during the campaign of Balalo Must Go, which I participated in, most people said that we, the Acholi people, we are haters, we are tribalistic. But the aspect of Balalo is not so much a tribalistic issue. The issue goes deep to identity of the people. Because these people go to specific areas where there are minerals, there are minerals resources under those areas. They move to specific areas with mineral deposit. In Acholi land, they go and block wells. They go and block public roads. They do a lot of impunity against the local. And they refuse to be assimilated into the custom of the people. So you realize that the aspect of Balalo is not just ethnic issues. It's tribal, it's politicizations coupled up with the aspect of ethnic cleansing. Senior Counsel Kimara will elaborate on that. But my question to Senior Counsel Kimara is, now you talked about the aspect of customary tenure being governed. Customary tenure system does not guarantee the issue of marketability of land. But how do we survive in situations where we live in a capitalized economy? Land market cannot be avoided. So how do the customary tenure survive in such a harsh situations we have been put in? Thank you.
Just the gentleman across from him, and then there's a lady down here.
Okay. Thank you so much for your submissions. By the names of Bazole Morris, I'm in LLB2. What a wonderful time like this to discuss the Balalo question. I'm handling such a project. In my coursework question, it's a Balalo question. I had a submission from Senior Counsel Dimara. I also had the submission from Counsel Kenny Luchamuzi. First things first, who are these Balalo? Where are they coming from? I like the submission from Dr. Tusasire when he talked about the headache. You know, it's good for you to know the cause of the headache than having painkillers, because if you have the painkillers, they will work for that moment and you will get worse after you having the painkillers. Who are these Balalo? Before we issue these executive orders, where are they coming from? You talked about them coming from the cattle corridor. But before they came to the cattle corridor, where are these Balalo coming from? And we have different constitutional provisions like Article 29, which talks about a right to free movement of these people. Yes, we have free right of movement. And I liked it when the lecturer from South Africa said we have to tolerate these people. But surely, there are some people you can't tolerate. These Balalo, you can't actually tolerate them. You know, I don't have sentiments like my friend. I've not participated in such campaigns before. But yes, we want to tolerate these people. But these people are acquiring this land. They are fencing off this land. They are blocking drainage channels. Like, surely, even if I wanted to tolerate you, would I really tolerate you? And Council Kenny Luchamuzi talked about federal. So, as I was trying to relate all this, by us creating a federal, are we trying to lock out the Balalo that for us, we shall govern ourselves, we shall lock out those people coming from elsewhere? So, what can we actually do to find these people to where they are supposed to be, apart from, because whenever we offer executive orders, they will keep loitering. Before you know, even me who can't tolerate them, they will come to me and I will have to tussle it out with them. So, where are these Balalo coming from, and what can we do to enable us have a peaceful nation where we shall not have conflicts with these people coming in whenever these executive orders have been issued? Thank you so much.
The lady in white.
Thank you, panel. Thank you, Ripek. Good afternoon. My name is Nisima Mary Patricia in Maya 2. My question is, the media and politicians have tainted the Balalo as colonialists, land grabbers, and as evil people. And yet, they are Ugandan, and as any of the people here, and even the actually people, by virtue of Article 237 and Article 26, yeah? But the reality is that the conflict is in contestation with the Constitution. So my question here is, how can we celebrate the Constitution, which is marking 30 years, but the reality does not meet it? Like, they are not at par. Yeah, that's it. And a colleague of mine has a question that, how can the law of trespass to land apply to the context of customary law?
I think that we'll take those for now in respect of our keynote speaker's time. He mentioned that he has somewhere he has to be, so we'll give 5 minutes to each of the panelists to respond to the questions that have been raised. Yeah. And you don't have to come back here.
Thank you. Thank you for your very, very good questions. I like coming to this place because the discussions are always very stimulating and diverse. And that's why academic freedom must be defended always at all costs. I think my friend Toko raises the issue of the ordinary Balalo who used to exist. What about them? I must say that there's not been a problem with that particular group of Balalo. Why? Because when they moved to areas like northern Uganda, in your village, they came and were welcomed in accordance with the norms and customs of that area. Not a superimposition. And there are so many Balalo who settled and have grown up and have had children raised in those parts. There is absolutely no problem with that category of people. Individuals who come and are welcomed. One of the things the arguments we brought before the Constitutional Court was for the court to understand what the custom is. How do you get land in a place like that? And that also answers Dr. Kebi's question. And we said that we unpacked the tenures, for instance, under the Acholi custom. Today, when you want land in Acholi and you go to Dr. Kavumba's home, it is a very simple process. I am Francis. I am from Buganda. I have come here to request you to welcome me to do some farming in your land. Then Dr. Kavumba will ask me a few questions to just interrogate whether I don't practice witchcraft, I am not coming to finish them, whether I am of strong moral standing, whether I'm not running from my community having committed a crime. It's what the English lawyers call a due diligence. He will conduct it, and if he's satisfied, he will say, okay, let me engage my community. He will say this land is part of the community. He will hold your hand, take you to the clans. He say, I've been approached by one Gimara, and he wants to farm. We have engaged with him. I have some land here. I am going to give him. He's going to farm. And he will settle. So what we are seeing is that we are dealing with a situation where that culture was messed up by the war. So now people return from the war and hardly have they settled in their original places. Then you have this influx of people who are coming without a recognition of local custom. They are coming with imposition, with disrespect, and that is the objection that you are getting. I hope that makes sense. People are saying, let's dignify Ugandans. We have come to Buganda here. Many people have come here. We have been welcomed. Sometimes you have bought land from Haruna Kanavi, very good friend of mine, but you don't go to him and just begin fencing near his land. You get it? And then you have another group, portions of the state, to protect you. You go to Mr. Kanavi and do the same things. And that's how they have been welcoming in terms of that. So I think we need to move away from this adage that these people are just, weaponizing this issue. Of course, there are groups of people weaponizing it to make it look like it is an ethnic battle. Far from that, I have told you, and I can repeat, I have done both legal research on this, I have done anthropological research on this, and I am just saying what you see here is a failure to understand each other as Ugandans, and that understanding is what some people are packaging to weaponize it, to call it tribalism, to call it that it is an infringement on the right to freedom of movement, whereas not. In fact, far from that, it is a misunderstanding and a misplacement of what the actual situation is. Yes, Dr. Jara, some people are weaponizing it for political purposes to continue that colonial categorization of people, that these people are a special breed of people, they are hostile. You see them, they are chasing us. That's the same language the British use. So we see that being used again. Instead of saying, what is the issue? What is the Constitution saying? What is the rule of law requiring? If the Constitutional Court has adjudicated this matter, can we all go and read the judgment, find out what arguments did the lawyers made? We made very serious arguments in that constitutional petition. We even went to the extent of describing the local tenure, how it is located. And all these issues, thankfully, the bench, which had very serious people, understood that case. And they asked us, and we submitted on what that culture, that understanding of land, how people would like it. And then what do we see? The continuation of a state of lawlessness, disrespect of clear constitutional court decisions, and we also see a misalignment of the acts of parliament that are supposed to articulate this very clearly, is what we are seeing. And that is the problem. That's the elephant in the room. How do we build a country that respects the rule of law, where we respect each other, each community respects each other? And that is why I am proposing that let's think about a dialogue. The British cobbled us together, took our land, and then when they left it with some of us, and some of us have continued to do the same things that the British did. That is why we don't have lasting peace. We have to face the elephant in the room, speak about transitional justice in very articulate terms. For this Uganda to move forward, what do we need? And yes, Dr. Kavumba, part of it will be a conversation. You guys, we have given you all our land. Why don't you give us some of the land? That is a process that can come through dialogue, that can come through conversations. And never make the mistake to think that the people of Uganda are incapable of having that conversation. We need to squarely face that conversation and put a stop to things that are not working, and we begin to realistically face each other as Ugandans. If people are shouting Balalo must go, why? Are they being tribalistic as simply as people would like to be it? No. This is a group of people who are from war. They have hardly settled. They have hardly been compensated. These are people who had their own cows. They had Balalo, Mr. Toko has told you, they would come and milk. They don't have those cows anymore. There is poverty. How much is land being bought from these people today? Do you know how much they are buying this land from these people? An acre sometimes it's 200,000, sometimes it's 80,000. And is the person you are buying from land able to sell the land, considering the connection of land to the clan? Is he able to sell? And this is why we need to stop being lazy. As lawyers, we need to understand how do you deal with customary land. Let's not put it simply because title, I have learned land transactions. LLB what? 2. It is title search. That's all I know. No, we have the duty to represent our people in the way they understand. Little wonder that today, the Hill report says that the legal profession, both the judges and the lawyers, only address less than 10% of the legal problems in this country. So all of us here are irrelevant to Ugandans. Why? Because we have not understood those simple things. How I own land with my team will just say, hey, land title. Somebody asks about trespass. What is the basis of the question of trespass? Is again the Muzungu law. Trespass from the Muzungu. How do you deal with it? But if you stretch a little bit, you will find that things of trespass were actually well dealt with. Guys even had natural boundaries. Haven't you seen Mutabu and all these things? They know how to deal with trespass better than the surveyor today who has done a degree. An old man in the village, by the way, is able to resolve a trespass matter on land better than many surveyors. That I can tell you from experience. But have we accommodated that knowledge in our land transactions? Have we accommodated those state actors in our land transactions? Have we given them space? Is something I need us to think about. Chakabumba, Article 32, spot on. There is no debate about, again, the Limitation Act, who brought it and for what purpose. If the Constitutional Court has said, go back to colonial, the Limitation Act must collapse and will not be the first. In Australia, you see they are facing this problem. The Mabo versus Queensland case is a historical case that speaks to protection of indigenous rights in more depth than you can ever think about. Then I think, Dr. Jara, it is both. It's both a weaponization, but also a disenfranchisement. And we can have that discussion much later. I think that gentleman asked me about land market access. Again, this fallacy of commoditization of land was an innovation brought about by development actors to make land a commodity for sale. And you need to go back and clearly look at who was behind the Land Act and what did they say. Part of the conversation was, let's kill off customary tenure. It's a backward system. And in my paper, I have cited reasons why the government wanted to kill the customary tenure. It's not my points. Those reasons are provided for in the land policy of 2013. They called it backward. It's everything wrong. And that is the problem I see, that what is ours is backward. Then what is for the Muzungu, including mortgage and all these things, is modern. Africans have always dealt with issues of land. We know what to do. We just need to represent what our belief system is articulately as lawyers. So land market is not an issue. I think what people are saying, respect us, dignify us enough, let's transact on the basis as Ugandans, not on the basis as a weak group of people who have just come from the war. We have hardly settled, and you are throwing all these things to us. I give you an example to close. Somebody went to a place called Pabo. He got the head of a family, and he said, I have 80 million here. Give me 200 acres. The guy had basically never touched 1 million shillings all his life. And for the first time, you are dealing with a situation where somebody is showing up with 80 million. What does he do? He takes the money. You know what that money did? It destroyed him and the family. Because while he did, he went to the bar. No capacity is from war for everything. People have no capacity to even manage something like 80 million shillings. So that money destroyed him. He started purchasing prostitutes from Pabo. Then he found that in Pabo, the prostitutes, he had finished all of them, they were cheap. He came to Gulu town. In Gulu town, he spent, until people in Gulu told him, now try Kampala. He came to Kampala 2 days, the money had been eaten and finished. So the guy went back, they even fundraised money for him to go back to Pabo. No land, didn't consult his family, and the money is gone, land is gone. So the question is, a group of people that are vulnerable, that have not been repaired from effects of war, that have not been organized, to what extent can you say, in the words of the law of contract, that you are dealing on the basis of consensus ad idem? Can that be consensus ad idem with people who have created a generation that has grown in camps? And that's why transitional justice is important. Let's have a conversation. Let's not take advantage of the weaker members of society under the guise that there is a more powerful Europe, a British-built state that can use power, to use all these things. Let us pick every Ugandan weak, and let us use the law first to protect the more weaker people and the more vulnerable, because me, I'll fight for my rights. What about that man in Pabo? Was that consensus? Absolutely not. So this issue of Balalo is beyond just the Balalo issue. It's a national conversation. I am happy that we are here and we can continue talking about it. Thank you.
Thank you very much. First of all, Madam Moderator, I am fascinated by the rich wave of intellect that has come from the audience. The questions were very testing and very interesting. When I was here at the law school, constitutional law and environment were my best subjects. So I would like to attempt to answer the first question directed to me over what causes the gun rule scenario. The society in northern Uganda is fragile. Who has made it fragile? Partially because it has been made fragile by the leaders today, the top leaders. I don't think they have provided an answer to the long-running Balalo question. As we celebrate independence anniversary today, I would like to borrow a leaf from the constitutional process. It is said that 63 years ago, we got our independence. What does that mean to us? If we say we got our independence, the sharing of the fruits of that independence are embedded within the local government. If the local government is weak, so nobody can claim that we are independent. Because if you are in the local government, what are you governing? What is your role in government? That is why the proposal that Uganda resorts to a regional government order, a federal system of government, is the best so far, because it will enable the regions share power between themselves and the center, so that they can fight corruption. Can a district fight corruption effectively? A region can, because it has an infrastructure with some autonomy. under the federal rule, power can check power. A district cannot check power in State House. But Acholi Parliament or Buganda Parliament or Ankole Parliament can check corruption in the center. So I thought that it was necessary for you to understand that part of the misery surrounding society in areas where the Balalo live is blamed on the leaders. Top leaders in the district, in the region are very weak. And there is no functional infrastructure capable of marshalling those who are in power. I have been fascinated also by the question of Dr. Kabumba. Thank you very much for the question you put. I think it is the gist of the matter. I came with some 10 or 15 copies of the paper, the giant paper I delivered recently to commemorate the Kabakazi scenario of anniversary. I think I'll leave them behind so that you distribute them to the students who are constitutional minded. Now, the question of Buganda, the Buganda question, is exaggerated without reason. In terms of wealth or economics, the states or the regions can compete and they can profit from the competition. Buganda does not have any material content that is worrying. They have got human resource, they have got a spectacular culture program, and they are welcoming. Even the Baksimba dance can make them rich. But you cannot relate Buganda to Kisoro in Kabale, or to Bunyoro, or to Karamoja. So people think that when we develop a federal system of government, the Baganda will become richer. We don't have wealth, but we have good land where we can command in terms of agriculture practice. So I think that the example you gave, Dr. Kabumba, is also answerable. As a student of federalism, I do not know of any federation where you have uniform states in size. There are always variations. Federalism evolves and survives circumstantially, and it does not depend on size. Otherwise, Switzerland, which is much smaller than Uganda, is one of the best economies of scale in the world. Even the very, very powerful people want to store their money in Switzerland. So I would like to think that the example of Koki you gave does not rise because President Museveni and others were the one pumping through these leaders, sectional leaders, to riot so that Buganda fails. But Buganda did not fail, and the matter has now been handled. These particular peculiarities exist in every federation. Where the peculiarity is excessive, usually they term that scenario a unique state which can be handled squarely, uniquely, in an asymmetrical manner. A case in point is Canada. The asymmetrical region is Quebec. Another case is United States of America. The asymmetrical case is California. But being asymmetrical, being asymmetrical is also a rewarding in economics, because once that state performs well internationally, the profits acquired will benefit the entire republic of the country, and you will all benefit. Those small states can be assisted through equalization grants and also resources inherent in their respective areas. So the question of peculiarity is the masterminder of federalism. And federalism depends entirely on an agreement. It comes from a Latin word called fedus. That sensation in fedus means that once you make a contract of a federal nature, you are as if you are making it between you and God. It is an assurance in publication. The Kitevu student, thank you very much for appreciating the little I was able to do. At Kitovu, I was president of the debating society almost throughout my time. How do we influence, how do we avoid the influence of money? That question is also very good. Let us now look at the scenario in Uganda today. Why is there a lot of havoc in the elections? Partially because the government itself has narrowed down the practices of political parties. Before that was done, a political party would command that so and so can become a member of parliament. So and so can become a presidential candidate. But now there are no highlights which can help political parties to find who is best for putting forward as a candidate. So the best we can do in a scenario of this kind, if you can take my technical advice as a practical politician, is to enhance public advocacy. You create as many areas of public speaking in public rallies, and you articulate the points squarely so that people who are confused come to light. And that is possible. In the case of Acholi, I think Acholi requires a federal government, but good enough under the Constitution of Uganda, Article 170(83) says the regions of Buganda, Busoga, Bunyoro, Acholi, and Lango are deemed to have agreed to go federal. Federalism in terms of that nature could even be brought or started as a pilot project. What people are missing in the scenario of the Lancaster House Conference, to let them, some people say that that was quasi-federalism. It was not quasi, it was a starting point where eventually people would go on enjoying the expansion. A case in point is in 1989, where Professor Mamdani from my political science department at Makerere, I was also there under Professor Mazui as a young child, who mentored me to the extent where I became a commander in political government. I think that is also very, very much possible. For example, where you find the catastrophes in terms of boundaries, what do? You can use the newspapers. Dr. Kabumba is using his scenario in the Observer newspaper in a very good, fascinating form. By the way, those of you who do not know my history would be surprised to learn that I joined the Makerere University before I did my A-level. When I was debating at King's College Budo in a scenario of a wide spectrum of schools, I emerged out the winner after combining my efforts with a senior 6 student. So Professor Mazui, I was in senior 2. Professor Mazui could not believe that I was in senior 2. He attracted my parents that they accept that I spend my holidays in Makerere, and eventually, even before I became an official student. And the little I can share with you in terms, I dwelt on the word intellect. Professor Ali Mazui was such a powerful political scholar that his definition of an intellectual stands up to today. In his own words, he defined an intellectual as a person who is fascinated by ideas and has acquired the skill to handle those ideas effectively. Thank you very much indeed.
Thank you very much for your patience. I can see the energy is going down, but we are coming to the end of it all. And I would like to invite Dr. Pius Ojara to give concluding remarks, and thereafter, in 2 minutes, yes, and thereafter, Dr. Businje Kabumba will do the same on behalf of Eurepec.
Thank you very much, keynote speaker and respondent, and the representative of the Dean. I think it's quite enlightening that what we are dealing with is a national question. and it's a process that requires a lot of conversation, a lot of research, a lot of questioning, and I want to thank the keynote speaker for the time invested in going into the central issues around this, and Honorable Kenlu Chamuzi for the energy, passion, and experience you brought to bear, and of course, the representative of the Dean with a scholarly astuteness that in a short, sharp way brought to the core the national question conversation. Thank you very much.
And now Dr. Businje Kavumba, concluding remarks in 2 minutes.
Thank you, Mary. I think since we have saved 1 minute from Dr. Pius, I'll use 3, maybe 2.5. So I think one of the things that has come out is the questions around identity and dignity. That it's in some context not enough to talk about willing buyer, willing seller. And Dr. Ndlovu, I think this came up in our discussion on Monday. I think you asked around about conflicts and when do conflicts end. And I think one of the points that have been made here, Senior Counsel Francis talked about conflicts at various stages. And incidentally, Honorable John Ken kept talking about Independence Day today. And I saw Dr. Pius about to correct him. Incidentally, there are 2 Independence Days. There's 8th October, which is today, where the special relationship between Bulange, Buganda, and the British ended formally on 8th October. So it's not a mistake, actually, to refer to today as the Independence Day of Buganda Kingdom, but it also points to a continuing question, continuing stories. And I guess, Dr. Pius, for RLP, the question really, the central place of transitional justice is important. So we talk a lot about justice. This conference is called the Annual Conference of Human Rights, Peace, and Social Justice. So it seems there are different kinds of justice. There's the legal one, but I think the keynote address has prompted us to think about justice in broader terms. Not just legal justice, but political justice. Whether we call that political justice social justice, or we call it transitional justice, it's an invitation to look beyond the minutiae of law, the positivist sense of this is what the statute says, this is what the Land Act says, this is what the Limitation Act says, this is what the Constitution says. It's an invitation to aim towards a justice that is fair, that makes sense for everyone. And I think that's something we have to think about. Finally, I think the question around executive orders has been far-grounded. What does it mean for the president to say executive order number 1, number 2, number 3? What happens when those orders are inconsistent with the Constitution? And I think that's something we have to contend with. Now, finally, Francis asked us to think about the Mabo case. And incidentally, the Mabo versus Queensland, in terms of what it means to be indigenous and the meaning of the depth that that concept brings. Incidentally, that case was cited to the Constitutional Court in the United Organization for Better Development case versus Attorney General. It was extensively cited, and the court was faced with this concept. And the Constitutional Court dodged it. So we have, Francis, it seems the case you litigated begins to grapple with this question. The Batwa case dodged it. And so it seems there's work to do also conceptually and normatively. And RLP, perhaps this is something we need to think about jointly. So I think there's nothing left for me to do but to thank everyone, to thank the keynote speaker, the respondent, Dr. Pius, Mary Auma, the inimitable, the one and only, the HURIPEC staff that did a lot of work behind the scenes, Dr. Ndlovu, thank you very much. And of course, everyone, thank you very much. Asanteni. Bye-bye.